Good afternoon, everyone, and welcome to the monthly meeting of the San Fernando Valley Unit of the League of Women Voters of Greater Los Angeles. I'm substituting this afternoon for our unit chair, Joyce Batten, who could not be with us today. For those of you who are not League members, just a little background information. The League was founded in 1920, the year that women won the vote. And our mission has always been to educate voters and to encourage civic engagement. We are a nonprofit and nonpartisan. We never endorse candidates, but we do study issues, we reach a consensus, and we advocate for those issues. We invite you all to become members. We welcome both women and men. So before we introduce our speaker, I have an announcement. Our executive director, Dr. Nosh McTaggart, is going to tell you about the annual convention, which is coming up soon.
Hi, everyone. I just wanted to introduce myself. I'm Dr. Nosh McTaggart. I wanted to let you know we will be having our annual meeting on June 24th. We will be sending out materials virtually and we'll be giving you more information in the next week or so. But we hope to see you all there. And given that it's virtual, we hope that, that gives accessibility for more people to join in. So we're looking forward to seeing you. And as I said, details will be coming soon. So thank you all.
Thank you. And now the chair of our program committee, Jean Thompson, will introduce our speaker.
Okay, I'm very privileged and honored to introduce our speaker today. Cary Franklin is a professor of law at UCLA School of Law and faculty director of the Williams Institute, a research institute at UCLA focused on sexual orientation and gender identity law and public policy, and the faculty director of the Center on Reproductive Health, Law, and Policy, an innovative new center engaging with community organizations, scholars, lawmakers, practitioners, and advocates. And in her spare time, she writes items for Harvard Law Review, Michigan Law Review, NYU Law Review, Supreme Court Review, and many more. Then in her other spare time, she teaches in the areas of constitutional law, anti-discrimination law, legal history. Her work focuses on the historical development of conception of equality in American law and how this history influences the shape of contemporary legal protections in the context of sex, sexual orientation, gender identity, and race. Of course, she's well-versed in the history of Roe versus Wade and the Dobbs case. Professor Franklin will update us about the implications of the Supreme Court's ruling in the Dobbs case, what has happened since then, what is currently happening, as well as what the future holds for reproductive rights in this country. I won't go on with all her background because she will have no time to speak. So we are really pleased to introduce UCLA Law Professor Cary Franklin, covering the current reproductive rights in U.S.
Thank you so much, Jean, and thank you to all of you for being here. I really enjoy speaking to groups about the Constitution, and I particularly enjoy speaking to groups that are working on voting, because that is one of the things that is absolutely central to our whole constitutional design in this country. And I actually wanted to start there before I move more specifically into Dobbs, and just say that, as you know, and I think it's quite apt to bring this up, given the recent coronation in England. You probably saw the robes and the horses and the pomp and the ceremony. Well, America was founded and our system of government was designed in contrast to a monarchy. And our Constitution very explicitly in creating the United States and creating that union of states several hundred years ago, it explicitly said that the power in this country comes from the people. It was a very innovative new theory of government. And the idea was that the power would come from the people. And the Constitution starts like this. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, secure the blessings of liberty to ourselves and our posterity, we, the people, do ordain and establish this Constitution of the United States of America. That's not just flowery language. That is the people of the early United States of America getting together and saying that the people will be sovereign in this new country. It's an experiment where the power will not reside in a king. It will reside in the people. And this was quite a radical new idea of government. And we are still living with this experiment several hundred years later. And the experiment only works when the people participate and vote, and when their votes count, and when they're not blocked from voting, and when they're able to have a say. That's what this entire experiment rests on. And as you know, we've seen some threats to that lately. The threats have been legal in terms of blocking people from being able to vote. There have been accusations of stolen elections. There have been all sorts of shenanigans that you've heard about in the news. But there has also been the kind of softer demoralization of people, the sense that the system, or the propagation of the idea that the system doesn't work, voting's not going to solve anything. People get discouraged and then they don't vote. And that's another way that this experiment is threatened. So everything I say today has that as the background. The idea that this Constitution in this country belongs to us. If we want it to look like we believe it should look, we need to get involved. We need to vote. We can change it. We have changed it. And we need not to pull back when we feel demoralized, but redouble our energies when we feel like the law is not reflecting our views, the views of the majority. And the only way to get beyond that is for the majority to become more empowered. And right now, I think that's threatened. And that's the backdrop against which I want to talk about the Constitution as it relates to reproductive rights and Dobbs and Roe versus Wade. So we have a situation in our country where the Republican Party, really starting in the 1980s, prioritized judges. That was one of the focuses of the Republican Party. We need to elect Republicans so that they can appoint judges that will implement Republican views. There was a lot of fundraising on that. There was a lot of campaigning on that. Republican voters were told again and again and again, if you want courts that reflect your values and your views, elect us, send us money, we will win back the courts, we will get courts that reflect your views. That has been a spectacular success. The courts have shifted very, very, very far to the right in recent times. Donald Trump appointed more judges more quickly than his predecessors. He really got on that issue, or the people in his administration really got on that issue. And so now the courts have shifted very far to the right, and you're seeing the effects of that in all sorts of areas, including gun control, including this summer's affirmative action decision, including reproductive rights. Democrats did not make the courts as much of a focus. People thought maybe Barack Obama would change that. He was a constitutional law professor, so maybe he would prioritize the court. But even he didn't focus on the courts the way the Republicans had. And we are now seeing the result of that unequal allocation of resources and time and money. So we have a court system now that has shifted very far to the right relative to where it was a couple of decades ago, so that when the Dobbs case got up to the Supreme Court, it actually wasn't a surprise what was going to happen, as the party that it was able to appoint the justices that made the majority in Dobbs specifically said, vote for us, give us money, because we will put justices on the Supreme Court that will overturn Roe. They made good on that promise. That's what they said they would do, and that's what they did. So let me give you a little background, a little bit more depth on the Roe decision and just constitutionally what it said, so we can think about the implications going forward in terms of Dobbs. So as you know, in 1973, the court decided Roe v. Wade. Roe v. Wade said there is a right to abortion protected under the United States Constitution. Right? Last year in Dobbs, the court said that was a mistake. For the last half century, there's been an improper interpretation of the Constitution. It does not actually protect the right to abortion. Okay, what exactly did the court say? I'm going to back up here and say, when the Constitution was originally enacted in the 18th century, it had some serious flaws. Our original Constitution a couple of hundred years ago had some serious flaws. One of the largest of which, there was no larger flaw, was that it protected slavery. So the original Constitution said Congress can't end slavery for a couple of decades. It said slaves will only count as 3/5 of a person for allocation of representation. It said there was a fugitive slave clause that said if slaves managed to escape and get to a free state, the free state would have to return them back to the slave state. Women were completely omitted from the original Constitution. There were absolutely no protections for women. So this original Constitution, which was a 1789 document, had some pretty serious flaws, in addition to its genius in terms of allocating the power to the people. It had a genius democratic theory, but it had some real flaws also. And it failed to keep the country together, right? We cracked open in the 1860s. We had a civil war. The Constitution could not hold the Union together anymore. And after the Civil War, we came back together and we amended the Constitution. And we passed what are called the Reconstruction Amendments. The 13th Amendment banned slavery. The 15th Amendment gave Black men the right to vote. And the 14th Amendment was the broadest of these Reconstruction Amendments. It guaranteed liberty and it guaranteed equality, guaranteed liberty and equal protection. So after the Civil War, our Constitution was amended to protect your individual liberties more strongly and to give you a right against the government to have equal protection and to have liberty. Here's the difficult part, or I think the fun part about constitutional law, but the challenge of constitutional law. Our Constitution did not list what those liberties are that were protected. It just said you have a right to liberty. So we don't know what specific liberties you have, right? The fact that liberty is protected doesn't mean you have freedom to do whatever you want. You can't drive 80 miles an hour in a 30-mile zone and then say, hey, I have liberty under the Constitution. You can't stop me, right? You have to pay your taxes. You can't claim, hey, I have liberty. I don't have to pay my taxes. There are only particular core, special, fundamental liberties that are protected under the 14th Amendment. So what are those and how do we figure out what they are? Well, for a long time after these amendments came into place, they didn't do much for the people out of power, namely people of color, Black people, women. These people couldn't vote, even though the 15th Amendment gave Black men the right to vote. They still had a lot of trouble voting, as did all women for a long time. And the courts didn't interpret liberty and equality to protect these people. But that changed, and it changed through the actions of social movements. It changed through the civil rights movement, the women's rights movement, the disability rights movement, Chicano rights movement, the LGBT rights movement. They organized, they marched, they argued that liberty and equality should protect them. And over the course of the 20th century, they changed people's minds. And judges are people, and they changed judges' minds about the kinds of rights that were protected under liberty and equality. So we got a 75-year arc of decisions that reflected these changing ideas. So we got in 1954, Brown versus Board of Education. It said segregation is unconstitutional. It violates equality. That's not equality. Right? We got Loving v. Virginia in the late 1960s that said there are all these anti-miscegenation laws. They prevent Black and white people from marrying each other. You know, there's a right to marry. That's one of the liberties that's protected by the Constitution, and it extends to everybody, not just white people marrying white people and Black people marrying Black people. Around the same time, we got Griswold v. Connecticut. You have a right to use contraception. In 1973, we got Roe v. Wade. You have a right to abortion. In 2003, we got Lawrence v. Texas that said two people of the same sex have a right to have sex. You can't criminalize consenting adult sexual relationships just because they're between people of the same sex. And then in 2015, we got Obergefell, which said, you know, that right to marry that's protected under the Constitution, that extends to people of the same sex as well. So the court, it stuck to its core principles, which is that there are certain liberties that are protected, say the right to marry, but it expanded the ambit of those rights over time as we realized that we were wrongly excluding some people from those rights. Dobbs, for the first time in this arc, takes away a right that had been granted over the last 75 years and says that one was a mistake and we don't actually have it. So let me talk for a second about what the court said about why and how we tell what liberties are protected under the United States Constitution. Right? In Roe, the court had said, we have these liberties that we've all agreed are important. You have a liberty to bodily autonomy. You can refuse medical treatment if you don't want it. You have a right to privacy. You can make certain decisions that are really important about your sexual life, your relationship with your partner, the way you raise your children, and abortion falls within that. That's a right that falls within that category of liberties that's protected by the Constitution, that's always been protected. Maybe in the past we didn't understand that abortion fell within that category of liberties. We didn't understand contraception fell within it. We didn't understand interracial marriage fell within it. We didn't understand same-sex marriage fell within it. But we've always valued bodily autonomy, privacy, equality, and those overarching rights are broad enough to include these things. That was Roe v. Wade. And for 50 years, that's what the court held to. But in Dobbs, the court said, actually, we're going to implement a different test. The new test is, was the right defined very specifically, deeply rooted in American history and tradition? The court said, only the rights that specifically have always been protected are the ones that are protected under the Constitution. In other words, we don't have an evolving understanding of equality and liberty. That category doesn't grow. The things that are protected are only the things that were protected at the beginning and that the people who passed those amendments believed were protected. So if you can show that your right was always protected throughout American history and tradition, it is protected in the Constitution. But don't come to us with new rights that haven't been protected for hundreds of years, because those aren't protected in the Constitution. Now, you may have seen in the media, the court goes back in time and it cites people from the Middle Ages. It cites people from the 17th, 18th, 19th century, saying that abortion is wrong. Most controversially, it cites Matthew Hale. He's a 17th century jurist. He conceived that he articulated the theory that husbands could never be guilty of raping their wives. He sentenced women to death for being witches. He was an extreme misogynist who stood out even in his time. Justice Alito cites Matthew Hale and says, look, this guy said abortion was wrong. So historically, abortion has been viewed as wrong. It has not been protected. It's not protected now. I will note that at the time, obviously, women couldn't vote. They had no say in making the laws that govern them. Black people could not vote. People of color could not vote. They had no say in making any of these laws that we're returning to now as a result of the theory of interpretation that the court unveils in Dobbs. So that's in a nutshell what happened. The court said Roe was a mistake because the only rights that are protected are the ones that have been protected throughout history and tradition. Abortion was not protected as a fundamental right throughout history and tradition. It's not protected today. So that's Dobbs in a nutshell. I'll just say one thing, which is that both sides in Dobbs are claiming that they have the democracy on their side. So Justice Alito and the majority in Dobbs are saying, you have to look back to history and tradition because otherwise it's just judges implementing their own views and their own politics. And judges are not elected and judges are just inserting into the Constitution their preferred rights. So the only way to constrain judges and to know that it's actually law rather than judges' policy views is to go back into the past and see what rights were protected. And those are the only rights that are protected. And if you don't agree and you think more rights should be protected, go to your legislature and get some laws protecting your rights. But don't pretend that the Constitution protects those rights. So the conservatives on the Supreme Court, the majority of the Supreme Court, saying we are being democratic, but the democracy that we're honoring is the people back in the past. We're being true to those people that democratically enacted the 14th Amendment, that enacted the liberty protection. We're sticking with what they said. That was a democratic vote, and we're remaining true to it. The other side says this is woefully anti-democratic, that the vast majority, almost very few people on this call would have been able to vote or have any say for any of these laws back in the 18th and 19th centuries. It was a very small group of elite white men that were voting on these rules for everybody. By the way, the history is more complicated than the court is making it out to be. Actually, if you look back, historically, abortion was allowed until quickening, which was about the 16th to the 20th week. That's actually what the tradition looks like. But even leaving that historical dispute aside, I just want to flag that there is a historical dispute. There is a dispute about what our tradition actually looks like. But there's a broader point, which is that it's problematic to say that now in the 21st century and forever, as long as America lasts, the only rights that you have protected under the Constitution will be the ones that were protected when the Constitution was originally written in 1789 or when it was amended in 1868, because that wasn't democratic, because we didn't have any say, because those laws those views were enacted by a very small percentage of the population. It's called the dead hand problem. Why should the dead hand of 1868 control Americans in perpetuity when we have come to have new understandings of what liberty and equality might mean? So that's the fight between the two sides in Dobbs, and the history and tradition side articulated by Justice Alito wins out. Let me talk just briefly about some of the legal implications of this ruling. The first one I will mention has to do with law and doctrine. So if we are now living in a constitutional regime where the rule is the liberty and equality rights that you have are the ones that the ones that were protected back in the 18th and 19th centuries, a lot of our rights are under threat. Because let me ask you, was same-sex marriage protected 200 years ago? No. Was the right to same-sex sex protected? Was the right to contraception protected? Was the right to interracial marriage protected? No. None of those rights are deeply rooted in American history and tradition. Those are understandings that have evolved over time, that if we're going to have liberty and equality, it has to include those rights. Those are more modern conceptions of what liberty and equality means. So this theory of constitutional interpretation, where we look back to history and tradition and we only honor the rights that were always protected, threatens a lot of rights. A lot of rights that we've come to take for granted, a lot of rights that have been central throughout our lives. Not just reproductive rights, although contraception is importantly, I think now under threat in a very real way, but same with LGBT rights, and same with some of the rights related to race as well, because those decisions like Brown versus Board of Education and Loving v. Virginia, which was the marriage decision, they didn't look back to the 19th century and said these things are rights protected. They said we have come to understand that equality and liberty include these things. So all of that is threatened by this theory of interpretation. But bringing it down to the ground and to our topic today, there are a lot of immediate and quite substantial effects on reproductive rights that we've already seen go into effect. So more than a dozen states immediately banned abortion. The view is that it'll probably rise to about half of the states banning abortion. And these bans are quite absolutist. A lot of them do not contain any exceptions, do not contain exceptions for rape or incest, do not contain exceptions for developmental issues with the fetus, do not contain exceptions for the health of the pregnant person, do not contain exceptions for age. If you're 10 years old, if you're 40 years old, the law is the same for everybody. These are bans of a sort we haven't seen for a very long time, if ever, in the country. They're quite absolutist. And the effect has been, particularly in places where these bans have come into place, that people are unable to get the care that they need. Clinics closed en masse. People seeking reproductive health care in their doctor's offices and hospitals are being turned away. I'm sure you've seen this in the paper, but one of the things that these bans have done, because they're so extreme, doctors and healthcare providers are very threatened. They feel very worried about providing any kind of reproductive health care because they're not clear what they're allowed to do under the law and what they're not allowed to do. There is an extreme chilling effect. So I'm sure you've seen in the paper where people are arriving in hospitals with miscarriages, with ectopic pregnancies, with other complications, and they need care. And doctors are saying, I'm sorry, we can't provide care right now. We don't know whether it would fall under an abortion ban if we terminated a pregnancy. Literally, people are being told, you need to come back when you've begun the process of dying, because then we know that you'll fall within the life exception. These abortion bans have exceptions for the life of the mother. So then the doctors are saying, if we can prove without a shadow of a doubt that we are saving the mother's life, then we feel comfortable doing it. So please start dying, and then we can rush in and save your life at the last minute. You can understand how dangerous and threatening this is, not just to people who want abortions, but to really any pregnant person who is now not assured of care if something goes wrong with their pregnancy. We are seeing people not able to get drugs that they need. Obviously, medication abortion drugs, but some of the medication abortion drugs are also used for lupus and other type of medical conditions, and pharmacists are turning people away if they're a woman in reproductive age, saying we don't know if you're going to use this for an abortion. So there's a real chilling effect on pharmacists as well as doctors. You've probably followed the laws, like in Texas, they've passed a law called SB 8, which says that anyone can sue anyone who aids or abets the abortion of a Texas woman for $10,000. That purports to be able to reach across state lines. The idea is to try to stop anyone from helping anyone to get an abortion. We've seen effects on education. So the ability to get training in OBGYN care is a real concern now, because family planning, contraception counseling, and abortion services, those are required elements of OBGYN residency curricula that are accredited by the Accreditation Council for the graduate medical education, which is the national accrediting body. But there are states, obviously, where residents cannot get training in performing abortion because abortion is illegal. So we're getting medical students are not getting trained in reproductive services, and that goes beyond providing abortion. They're not getting trained in how to handle the kinds of complications around miscarriage, ectopic pregnancies, abortions, because they're not allowed to do that anymore. Some of the slack is being taken up by states. I know in California, in fact, at UCLA, we're taking some Texas medical students and we're training them in our programs and then sending them back to Texas to complete their education there. But Illinois and California and New York, we don't have the capacity to train all of the residents in all of the states that now won't provide people with training. So the problem is they're going to turn into reproductive health care deserts. And the problem also is doctors in those areas are leaving. People don't want to practice medicine under these conditions. So doctors are moving. Hospitals are shutting down. Again, these are not just abortion providers. These are OBGYN services more generally, where people don't feel like they could be in this area of medicine, train in this area of medicine, practice and obey the Hippocratic Oath and help their patients under these laws. But and that's understandable. But the problem is, then those areas care is becoming sparser and sparser and sparser for everybody. And we know that thousands and thousands of people who sought abortions in the last year are now being turned away. We have a lot of evidence and data, and more is being collected on the deleterious effects of being turned away on people's lives in terms of their educational opportunities, their employment opportunities, in terms of their well-being, their physical health, their mental health, in terms of their other children, because most people who get abortions already have children. So into the effects on the other children when their parent wanted an abortion and is denied it, there are negative consequences there. There's a lot of data being built up on the negative consequences across a whole range of indicators when people are turned away. And I'll just say there is a very strong disparate impact when it comes to race. Black and brown women seek abortions at higher rates. They are disproportionately living in states with bans, right? The majority of Black people, small majority of Black people living in this country live in the South. Those 13 states, there's almost bans in all of those areas. There's also the case that people with fewer financial resources seek abortions more often. This also has a racial disparate impact. It's really having its harshest effects on the most vulnerable people, the most financially vulnerable people, and Black and brown people in this country. I'll just end, and I'm anxious to have a discussion and hear your questions. I'll just end by saying there is a lot being done to push back as a result of Dobbs and against the consequences that Dobbs have created. You all are in California, I think. So California, very interestingly, California has secured reproductive rights. The support and security around reproductive rights, at least legally, has increased in California since Dobbs. Last legislative session, California legislature passed over 12 new laws that allocated money for training healthcare providers in underserved areas, for helping people coming out of state, for enabling nurse practitioners to perform abortions, protecting doctors and providers from civil liabilities in other states. In other words, if Texas tries to come after a California doctor, we've passed laws in California saying we will not cooperate with that law enforcement. Our judges and our law enforcement will not go after the people and do that work for Texas. In January, a law went into the books in California, or went into effect in California, saying that a medication abortion would be available on all the UC and Cal State campuses, which has is good for the students at those universities who are seeking abortion, but also has relieved the burden on the clinics in those areas, because now the college students can get healthcare on the campuses. So the people that live in those areas can get appointments at clinics that the college students aren't all eating up as much. And then California amended its constitution in November. It passed Proposition 1 that enshrined the right to reproductive freedom, including contraception and abortion, in the California Constitution. California was the first state in the country to specifically protect abortion and contraception in its constitution. And it did that to avoid a Dobbs-like situation in California, because what we had in Roe v. Wade was a court that for 50 years interpreted the word liberty in the United States Constitution to protect abortion. And then we saw in Dobbs that the court could say, whoops, actually, that was a mistake. Liberty doesn't protect abortion. Well, that's the same circumstance that was going on in California. The California Supreme Court interpreted the California Constitution to protect abortion rights, but a court in the future could come and say, oh, actually, that was a mistake. Liberty, privacy, those things don't protect the right to abortion. But now a court can't say that, because the California Constitution specifically says that abortion and contraception are constitutional rights. Michigan and Vermont also amended their constitutions in November the same way that California amended its constitution. So now 3 states have explicit constitutional protection. Just as importantly, Kansas and Kentucky voted down amendments to ban abortion in their constitutions. And I think that's quite important. Even in red states, the voters said, we don't want a ban on abortion in our constitution. And that's what I want to finish with, which is saying abortion is a very interesting issue, because the strong majority of Americans believe that people should have the right to abortion. Strong majority support medication abortion. Even in red states, people don't want the government going into people's bedrooms and families and doctors' offices and telling them they can't make these incredibly life-changing and important decisions for themselves. So this is an issue where the American people, and this has been true for 50 years, actually support abortion rights, but the laws don't reflect the majority view on this. And that's, I want to end where I begun by saying the only way to get out of a situation where you have laws and courts that don't reflect what the majority view is for the majority to assert itself, and for the majority to vote, and for the majority to make clear to the lawmakers that this is something they care about, that this is an issue they want to see action on, that they want the laws to reflect what the people actually think about these issues. So I would say, regardless of what your views on this topic are, please be involved, please vote, please talk to people, please organize. It's so important for the whole American experiment that everyone's voices be heard. And with that, I would love to talk to you and hear what you're thinking about.
Well, thank you very much. And we would like to ask a couple of questions here. We have some in the chat. And the first one is, what will the impact of the dormant Commerce Clause be if people try to mail contraceptives through or abortion pills through the mails?
I don't know. So the Supreme Court just issued a decision that was about pork production. So you wouldn't think it would have a lot to do with abortion. It was the National Pork Producers Council, and they were upset because California passed a law saying basically you had to meet certain standards in how you treat pigs that you're going to slaughter and sell for meat. So you have to have larger cages or whatever the animal rights view that laws that California had passed. The National Pork Producers challenged that and said that violates a provision of, or a theory of the Constitution called the Dormant Commerce Clause, which says that individual states can't discriminate against interstate commerce. And the pork producers are saying, you're discriminating against interstate commerce because you're making, we now can't sell our products to all the other states in the way that we want because California has put this law in that's going to affect how we do things, and it shouldn't be allowed to do that. And the Supreme Court, it's interesting. It upheld California's law. So it said that California was allowed to put the more stringent restrictions on the pork producers. That sounds like a progressive decision, but I think the concern among some abortion rights advocates is that really this decision has a lot to do with abortion, and that the next case will be an anti-abortion state putting restrictions on abortion that affect all the states and not being able to challenge that because they upheld California's law that affected how things are done in other states, that it'll be okay if there's an anti-abortion state that affects reduces or crushes or makes it more difficult to provide abortions in other states, that now the Supreme Court is going to say that's okay too. So abortion was kind of lingering in the background of this pork producers decision. We'll have to see. That has not come up yet, but that's the connection.
So as you were explaining the rationale for the Dobbs decision, it seems like it would then really look at rights law besides abortion. And it seems that other rights we've really taken for granted could be affected. And so is this, are there any limits on that? Or is this something that, going back to contraception and the other things like that, would they take the same view of these other rights that we thought were more secure?
That's a great question. I'm writing about that right now. I mean, the bottom line is we don't know. I think for me, just from a constitutional law perspective, I find it very worrying because I think the reality is where we are. The court has articulated a test that absolutely calls into question all of those rights. If the question is, was it protected in 1868? And that's what the court said was the question in Dobbs. Was it protected throughout American history and tradition? All of these rights that I articulated are not protected rights. So if the court is going to be consistent, then I think we have a very radical situation on our hands where rights we've taken for granted for a long time are going to be upended. Here's the thing, though. I don't think the court is going to go all the way in wiping out all of these rights. I don't think the court is going to wipe out the right to interracial marriage. But here's why I'm not, and I think that's for political reasons, because that's so extreme, the American people would not accept that. That would be a very unpopular decision. But this is what, as a constitutional law professor, offends me and frustrates me about this. The court will find ways, I believe, to save and preserve certain of the rights, because it would just be too politically toxic, and or they believe we should have those rights, even if they weren't protected in 1868. And so the court will find arguments to preserve those rights, and it just gives the court enormous amount of political leeway to save what it likes and get rid of what it doesn't like. I'll just say the way the court can do that is by saying there's been reliance on certain kinds of one of the arguments that the court made in Dobbs is nobody has relied on the right to abortion. So there's a doctrine that said if people have really relied on this right, even if the original decision protecting it was wrong, we might still uphold it. That's a doctrine called stare decisis, let the decision stand. If people have relied on it and built their lives around it, maybe we will preserve it, even if originally we wouldn't have held that it's a right. Controversially, the court in Dobbs said nobody has relied on a right to abortion. But they could come back and say, but people have relied on a right to XYZ. And this is what I don't like as a constitutional lawyer, because I think this is just a completely unprincipled area where the court can just find a way to uphold what it likes and to get rid of what it doesn't like. And there's very little constitutional law involved. And there's just a lot of politics involved. And the court's pretending that it's law, but actually just inserting its own views. So I'll just wrap it up by saying, doctrinally, yes, I think all those rights are threatened. And if the court were going to be doctrinally consistent, I think a lot of those rights would disappear as soon as we got a case. I don't think all those rights would disappear. We're just going to have to wait and see how far the court wants to go. It's in the court's hands, and that's not how this is supposed to work.
So if some of the states that are now banning abortion decide to ban birth control, is that likely to be the way that it gets to the Supreme Court?
Sure.
And
some of this, there have been attempts even in states like Louisiana to ban Plan B and IUDs, which some anti-abortion advocates erroneously, scientifically, this is erroneous, but they call those abortifacients. They believe that some forms of birth control actually should be classified as abortion. They're already starting to ban those kinds of birth control. So we are seeing attacks on birth control. We will see more attacks on birth control. We will see pharmacists who refuse to dispense birth control because it goes against their religious views. We will see all sorts of attempts to erode people's access to contraception. And that's how that would come, eventually that could get to the court if a state decides to bar certain kinds of birth control or access to birth control. I think it'll be, before we get to that massive Supreme Court question, I think though it'll be restriction by 1,000 cuts. I think it'll be also like attempts to have insurance not cover, attempts to have Medicaid not cover, attempts to have doctors and pharmacists get exceptions if they don't want to cover contraception, banning certain kinds of contraceptions by calling it abortion, banning schools from talking about contraception or distributing contraception. These are the kinds of things that we will definitely see. And I have to say, if that eventually got up to the Supreme Court, I am not at all confident that this court would say that the Constitution protects the right to contraception. Not at all.
Another question we have in the chat is, are the Comstock laws still on the books where they are, where they had been before?
Yeah, so wow, you all are following this in great legal depth. Oh goodness. There is a federal law passed in the late 19th century due to the campaigning of an anti-obscenity, anti-sex, misogynistic political figure named Anthony Comstock. He did not like, he was a very traditional anti-sex crusader. He wanted women back in the home quite explicitly. He wanted them having lots of kids. He did not want anyone reading any literature that he called obscene. So this law he got passed barred using the mails and even carriers like UPS from shipping anything that was obscene or could be used in an abortion or was a contraception. You can't ship any of this stuff through the mail. That's a Comstock law. And they went after medical textbooks that showed pictures of people's anatomy. They went after Lady Chatterley's law. They went after contraception, abortion, books, medical information, all of this. But for a very long time now, courts have interpreted the Comstock law to say you can't use the mail to ship things are going to be used for illegal purposes when it comes to the abortion part of that. Basically, this law has been interpreted out of existence. This is a very archaic law that we haven't obeyed in this form for a very long time. It just popped up after Dobbs. And that Texas judge in the FDA mifepristone case cited the Comstock law. They're dredging up these laws from the 1870s and trying to say part of the problem is medication abortion is being shipped in the mail. We have a federal law that says you can't ship anything related to abortion in the mail. So I don't know what to tell you about that. If we go back to the days of 1870s interpretation of the Comstock Law, we're not talking about going back to the 1950s. I mean, we're talking about going way, 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 way back before, to the time our great grandparents were born, and women couldn't vote and, couldn't work, and things looked very different. This law, the thing is, it wouldn't just bar medication abortion or shipping abortion pills. It says anything. So medical instruments, I can't even conceive of how broad this interpretation that the Texas judge gave to this law would be, and what it would do. It would be an almost unimaginable recurrence of something that has not been practiced for a very long time. I don't know what will happen with it. It's popped up. It hasn't really been adjudicated. We'll have to see what goes on with that.
There's another question that has to do with states who have a disproportionate number of Black and brown people that would be seeking abortions, explaining that denying them that right when their death rates and due to pregnancy are higher, is that, medical complications and risk of death are higher. Would that help get essentially that be a way to get abortion through in some places? They're looking at essentially looking at mortality rates for minorities or whatever. Would that happen?
So the Dobbs case involved Mississippi. Somewhere in the nature, I think it's somewhere in the area of 70 or 80% of the people seeking abortion in Mississippi were poor Black women. The maternal mortality rates in a lot of the abortion ban states are shocking. They are completely out of whack. They're completely different than the rest of the developed world. The maternal mortality rates in Texas and Mississippi and Louisiana do not look like maternal mortality rates anywhere else in the developed world. It is a shocking travesty how many women in those states are dying and having severe complications as a result of pregnancy and childbirth. Most Americans don't realize, I think, what the situation looks like and how dangerous childbirth and pregnancy are in these places with no health care and serious health conditions. So that was one of the central arguments in the briefs in Dobbs, that the state is saying that its interest in banning abortion and shutting down clinics and doctors was to protect maternal health and life. So that's what the state was coming in and saying, our justification, the state has to offer a justification for its laws. So it was saying our justification, our interest is in protecting health and life. So the other side, the abortion rights supporters, the people who are challenging law, said, you cannot say that your interest is protecting health and life when you do nothing to protect health and life. You didn't expand Medicaid, you don't have health insurance, you don't have nutrition or housing or substance abuse or prenatal care or postnatal care or pregnant worker protection or anything you could do in the policy arena to help pregnant people. You're doing none of it. The only thing you're doing is closing down clinics and banning doctors. So we're challenging your assertion that you are actually acting out of concern for life and health, because look at the Black women in your state and the dire situation they are facing when it comes to life and health. That argument did not prevail. That argument is still being made. So here's an important thing that I should have said, and I want to emphasize. We have 50 plus constitutions in this country. So Dobbs and Roe, those were being argued under the United States Constitution, and Dobbs held that there's no right to abortion protected under the United States Constitution. So now all of the activity has shifted to the states and state constitutions. And so these issues are now being litigated in a lot of states under the state constitutions. And these arguments are absolutely being made. And they will continue to be made, and they can also be made in the legislative context, not just, courts aren't the only thing. Judges aren't the only deciders. People are lobbying lawmakers to pass laws to try to address this maternal mortality and complications situation, and argue for reproductive health care and argue for increased prenatal care and postnatal care and abortion care and all the birth control and all that kind of stuff, using those facts and that evidence to try to persuade lawmakers to pass laws that would address those issues. So yes, those arguments are being made in state houses. They're being made in courthouses. They haven't won the day lately, but they are absolutely being made.
I have another question here. Says, might it still be possible to invalidate draconian state abortion laws based on equal protection clause, or has that ship sailed?
No, that ship has not sailed. That ship has not even left port yet. So that's another thing that I'm writing about. Roe got decided under liberty. And one of the reasons it got decided under liberty is only one of the protections I told you about in the 14th Amendment. There's also equality. But in 1973, in the early 1970s, Ruth Bader Ginsburg hadn't gotten started yet. How she became famous is she spent the entire 1970s convincing the court that sex discrimination was a problem under the equality branch of the Constitution. But Roe happened before women got protection under the equality provision of the Constitution. So you couldn't really bring an equality claim in Roe because women didn't get protection yet. But now women are protected under the equality. The equal protection clause of the Constitution of the 14th Amendment is understood to bar sex discrimination. So one thing, now that Dobbs has shut off the Liberty Avenue, there's renewed interest in attacking this as an equality question. And equality claims are being built and being put forward in court. And I just published a book chapter about it, and people are really interested in how this might not just be a freedom liberty question, but also an equality question for people for whom, being compelled to give birth to children that they wouldn't have chosen to do could affect all sorts of standing in society kinds of questions, education, employment, all that. So certainly we will see. We will see how that develops.
Okay, I have another question here. If it were possible to pass the ERA at this point, would that make any difference in all of this?
Oh, that's a huge question. I don't know the answer to that. I don't know the answer to that. I could say a lot. So if I were going to be pessimistic, I would say, well, who's going to, the ERA guarantees equality on the basis of sex. Who is the final arbiter of the meaning of that? The Supreme Court, right? So the Supreme Court is going to be the body that decides whether an ERA grants a right to abortion. The ERA does not specifically or explicitly grant, it will just say the Constitution guarantees equality on the basis of sex. If a challenge goes up, it's Justice Alito and his colleagues who are going to decide whether that provision includes abortion. So my view would be they would say no. And so in the immediate term, I do not think that this Supreme Court would interpret the ERA to grant abortion rights. However, when the American people mobilize and argue and say they support this, and if they were to pass an equal rights amendment, that would be a massive show of political strength and support and activity. And I think that could have long-term effects on changing people's minds, on we could have other lower courts interpreting it in certain ways. I think it would build strength and momentum. So I think it's important in that sense. I don't think it would be a quick fix at the Supreme Court.
And just another equality follow on here. If it looks like there's an effort to ban contraception, and would they consider banning the use of condoms, or is it something that's only directed to women? Do you see that going forward?
Yeah, that's interesting. Thus far, the attacks on contraception have almost all been directed at contraception that women use. And the argument is that condoms are okay because they are for STD prevention. They are not for, whereas the other contraception that women use could create abortions or just enable women to have sex without consequences. And those are being cracked down upon. And often condoms, and this is true historically, this was true in the early 20th century. And the case that got to the Supreme Court in the 1960s, Connecticut banned contraception used by women, but they allowed condoms for STD prevention because that was not seen as immoral in the way that women using it to prevent becoming mothers was seen as immoral. So there is still that kind of gendered differential when it comes to attacking birth control. I think that goes to the equality argument. I think it's a piece of support for the people who think a lot of this is about traditional gender roles and the enforcement of motherhood. And that lies at its core. I think the differential regulation of female contraception versus condoms, tends to support that. I will say, though, it's not that there's no attack on condoms too. I think there is some effort to get condoms out of the schools, to get education about condoms stopped, all of that kind of stuff. So it's not like there's no attempt to restrict any of that, but it is interesting to see the way the law treats some kind of contraception differently than other kinds of contraception.
Okay, and then there's another question here, which I will read, but I may get it wrong, but would actual biological differences survive immediate scrutiny under our sex discrimination texts?
I'm not sure exactly what that question is. I will say, so the way the court has interpreted the sex discrimination doctrine is that the state can recognize actual biological differences between men and women, but it can't regulate those differences in ways that impede women's abilities, that impede their educational opportunities or their employment opportunities, that reinforce traditional stereotypes, that force people into traditional gender roles. So the way the court has interpreted our Constitution, the government doesn't have to be sex blind. It can recognize biological differences between men and women, but only, the court said, only in order to celebrate those differences or to support people, not to hold people back. So that's currently the doctrine. And, we'll have to see how the court decides to apply that in the abortion context.
Okay, and I think I've covered all the questions that have been in the chat. I was really just wondering about essentially how does it, and you discussed it as being difficult, but if a woman is starting to have a miscarriage, and that's not uncommon, it's something like 20-25% of pregnancies go into miscarriage. Is that something that the doctors now are really not treating seriously in terms of continuing a D&C or a medication abortion?
Well, here's what they're worried about. So if you're in a one of the severest anti-abortion states that's passed a ban that bans abortion in all situations except to save the life of the mother, and someone presents to you and they're bleeding heavily from, they've begun to miscarry and they're bleeding heavily. Doctors are worried that if they perform standard miscarriage care, whether it be a D&C or whatever, that if a zealous prosecutor in this area decides that there was still a heartbeat or still some kind of life in the fetus, or the doctor didn't make sure that there was absolutely no life left in the fetus, even though the doctor could say it's dying. But if the doctor performed what could get characterized as an abortion, and that doctor can't prove that he or she thought the mother's life was in danger, that this person would die if that wasn't performed, that they might become a test case, that they might become something a prosecutor wants to go after. And so doctors are scared. I'll just end by saying it's really interesting. We set up this legal hotline throughout Southern California. And the idea was, we're going to get, now all these law firms are really interested in providing legal help and legal advice after Dobbs. Like all the big law firms in Southern California, all the most prestigious law firms in Los Angeles, they want to get involved with this work. They want to help people. So this hotline was going to hook up people who called in with problems post-Dobbs with these high-powered lawyers who were going to help them. So we've set up this network. We thought we were going to get a lot of pregnant people calling in saying, I need help. I don't know where to go. I don't know what I'm allowed to do. But instead, what we've gotten is doctors and hospitals calling us saying, we're scared. We don't know how to provide care to people. We don't know if we're safe. Can we do this? Can we do this? Can we do this? All of the things that we would do to take care of our patients in the past, we're now worried that some of it could make us violative of the letter of the law in a place like Texas. So all of the people basically who are feeling like they want lawyers are doctors and hospitals who feel very chilled and very scared that if they can't prove definitively that the person would have died if they didn't step in, that they might be doing something illegal under, say, Texas law. And you could imagine, these doctors, they could lose their license. They have kids, they have a practice, they have a family. They don't want to be put in jail. They don't want to stop being able to help their patients, and they are scared. And so there's just a lot of instances now where doctors aren't providing what they believe is the best care because they are concerned. I will finish by saying there are now a lot of lawsuits challenging laws that are doing this because these laws are so chilling and so vague. And again, the argument that the state is making in support of these laws is that they want to protect maternal health and life. And so the argument is, even on your own justification, these laws are irrational. They're not protecting health. They're not protecting life. These are contrary to health and life. They are hurting health and life. If you really cared about health and life, you wouldn't be doing this kind of regulation. So those lawsuits are going on. I think some of those stand a good chance of winning because of everything I just described going on.
Then there's also a question now, is what could be the remedy nationwide? Would it require a constitutional amendment, or could it be done with just a law adopted by Congress?
It could be, so both sides are interested in all of this at the federal level, and I'll tell you why. Our Constitution has a supremacy clause that says that federal law is supreme over state law. So a federal constitutional amendment or even a federal law would supersede state laws and even state constitutional amendments. So the big prize is really a federal declaration, and you could do that by amending the Constitution in either direction. You could amend the Constitution to ban abortion, and you could amend the Constitution to allow abortion, and then that would become the law of the land. it is nearly impossible to amend the United States Constitution. We haven't done it in decades. It's basically impossible to do. Our amendment process is broken. That's a topic for another day, but I will just say, I don't think a constitutional amendment on either side is imminent. It's very unlikely to happen. So then the question is, can Congress pass a law either banning abortion or allowing abortion? Congress is pretty dysfunctional these days too. If you've turned on the news lately, Congress is not getting a lot done. And then there's the fact that a lot of the Republican lawmakers in Congress know that an abortion ban nationwide would be wildly unpopular. Americans don't want that law. So Mitch McConnell doesn't want to pass a federal abortion ban because it would be so unpopular. It would be difficult to pass. That's not their top priority, though it is the top priority of anti-abortion advocates and activists who are working to do this. So I guess I would say we don't need a constitutional amendment. Congress could allow it or they could ban it. That would become the law of the land. But it's very hard to get Congress to move in either of those directions. So I think we're going to be in the states for this foreseeable future.
Okay, there's one question in here, which I'm not sure that it really figures in precisely to the discussion, but does changing the sex of children come into this argument too? And this is about having to have nationwide constitutional amendment or guaranteeing rights regarding sex. I
don't see immediately how it relates.
I guess it was mentioned as gender affirming care. Is that I'm not exactly sure how it relates either, but it was something that came up in the chat.
I don't think abortion and gender affirming care are immediately related to one another. I think that the campaigns against abortion and against gender affirming care are the same campaign. So actually in the states, there's a lot of the same activism. And I think part of the equality argument on the other side is that a lot of this movement we're seeing has a lot to do with reinforcing traditional gender roles and making sure girls are women and mothers and stay in their lane, and men are boys, people labeled male at birth stay men and do manly things and become fathers. And so there is a deep political and ideological interrelation, and it's a lot of the same people and organizations working to institute bans on gender affirming care and to institute bans on abortion. So they are issues that are deeply interrelated. I think ideologically, a lot of people see them as interrelated because there's an idea that they're both kind of liberating people from conventional gender roles in a way that might make people uncomfortable. So there is, it's the same states that are banning abortion that are banning gender affirming care. It's the same people, it's a lot of the same arguments. But I think in court, the issues are separate. They're separate legally. There's different arguments being made, and they're not all joined in one lawsuit.
Okay, we're getting down to comments, just lovely comments. We had apparently something from one of your students who said you were the best professor they've ever had the pleasure of studying under, and another one just basically commenting on how nice it was to have such a well-informed presentation. So I think we're kind of getting to the end, I guess, of our time. I kind of debated saying anything, but if I had a serious pregnancy issue back when I was 32, and I started to miscarry, And fortunately, they, everything turned out well in the end. But if they hadn't actually proceeded with the trying to terminate the pregnancy, I probably would have died. And because what they found out essentially caused the miscarriage was that I had peritonitis. And if they hadn't, if they just said, we're going to wait until it gets worse, I don't see how in that kind of a situation I would have survived. And so I'm taking a very personal interest in all of this. And it is really, truly distressing to see how people that are starting to miscarry aren't getting appropriate care.
Yeah, I think that one thing that advocates have been saying for a long time, but that the post-Dobbs landscape is making clear, is there's not a bright line between abortion and a lot of other obstetric care. A lot of the times that treatment for ectopic pregnancy, and often the treatment for miscarriage, is abortion, but we just don't use that word. And so we've kind of unscientifically and unmedically hived off this particular kind of situation, but it's largely a social and a political definition rather than a medical definition. I mean, doctors will tell you there's not a difference between what we're calling abortion and a lot of what I do in treating my patients every day for various kinds of situations. And I also think it's emerging that there's a fight over what you actually do to protect health and life. And so both sides are arguing that they are interested in protecting health and life. And part of the argument post-Dobbs had been the movement to stop abortion is being called pro-life, but it's putting a lot of people's lives at risk. And so there's now a contestation over what it would actually look like to protect health and life. What if we really cared about protecting maternal health and nurturing life, what policies would we put in place, right? That's arguments in a lot of the briefs about what that would look like. Would that look like expanding medical care, providing social supports for people, providing protections, nurturing kids? Or would it look like banning these procedures? And that's part of what the fight is about right now.
One other question. Do you know if the Texas law has been, if there have been any people who have been given the $10,000 for stopping somebody from leaving the state for an abortion or anything like that? Has that sort of bounty law actually been used?
I don't think it has. I am not aware of any $10,000 judgments yet. I am just aware of the chilling effect of just having that law in place. But we will. I mean, there are people trying to activate that law and put it into practice. So we will see what happens. But it's interesting, and this is a point that lawyers make a lot of the time. Even if the law is never enforced in a court, that doesn't mean it doesn't have an effect on a lot of people.
Okay. If there's anybody else who wants to put in a quick question, otherwise I think we're about ready to sign off. And thank you very much for your very interesting and description of what's going on today.
Yeah,
This has been fantastic. Thank you.
Yeah, I just want to thank everyone who attended today, as well as Professor Franklin. It has been a really excellent presentation and an outstanding day. Thank you for all the wonderful questions from our audience too. This will be our last program meeting until September, but we look forward to seeing all of you then. During the summer, we will be planning some more interesting topics and outstanding speakers. But before I close, I would like to thank our Valley Program Planning Committee, Joyce Batten, Sue Strickland, Ann Rushton, Laura and Neil Mitchell, Linnea Wren, who has researched to find our speakers, and a special thanks to Jean Thompson, who has handled all of the invitations to our speakers. And thank you to the league staff for providing your support, Paula and
Absolutely.
Naj. So we hope to see you in September. Thank you all.